make sure we continue to pay attention to what Ghislaine Maxwell is doing at the same time the Trump regime is engaged in a cover-up of her child sex trafficking ring that she was a co-conspirator leading with Jeffrey Epstein. We know the Trump regime is covering up the names of at least 10 other potential co-conspirators that we saw in the files that were released so far. We haven't really seen extensive grand jury material, FBI witness interviews, FBI survivor interviews. And one of the reasons may have to do with what could be being coordinated between the Trump regime and Ghislaine Maxwell as a pretext for some of the objections being asserted by the Trump regime not to produce some of these critical records. I believe there's probably millions of records that have not been produced thus far. I know the number out there is a few 100,000. No, in my review, I believe there's at least 5 million records, not documents, records that are out there. So Ghislaine Maxwell in this past week, and the timing's not coincidental, she filed what's called a habeas corpus petition to try to set aside her conviction based on what she's referring to as newly discovered evidence. She's using it for a number of things. Number one, I think she wants to help the Trump regime assert objections regarding material that could be related to her habeas corpus petition. And maybe that's one of the reasons that the DOJ is ultimately going to say that they're not producing all of these records. Stay tuned on that. Also, we know that the Democrats in the House Oversight Committee want to depose Ghislaine Maxwell, and rightfully so. She should be deposed, and she should be questioned, and she should have to answer questions. She holds a lot of answers, and she spoke with Donald Trump's former personal criminal defense lawyer, who's now the number 2 at the Department of Justice, Todd Blanche, who himself is complicit in this cover-up, the PPP, the Pedo Protection Program. And Todd Blanche was the first guy out there who said, we're just going to turn over rolling records, just some records, not all of the files. I mean, this guy's as complicit, I believe, in my opinion, in this cover-up of not releasing the files. But again, I have a First Amendment right to give you my opinion. That's what this is, First Amendment free speech. I'm giving you my opinions. Now, to give us a better analysis of Ghislaine Maxwell's habeas corpus petition, I want to bring in Katie Phang. You know Katie Phang. You love Katie Phang. She's now, of course, a host on the MeidasTouch network. So, Katie Phang, let me bring you in here and explain to us the import of Ghislaine Maxwell's habeas petition.
We get a 50-plus page, you're looking at it right now, folks, 50-page or so pro se petition that was filed by Ghislaine Maxwell, known co-conspirator, equally as culpable, hands just as dirty, child sex predator, child sex trafficker, child sex abuser. She filed it in federal court, the Southern District of New York, and it's a writ of habeas corpus. We've talked about habeas corpus a lot here at this channel, and folks, what Ghislaine Maxwell is seeking, she puts it out very clearly on page 4, although it's really not 4. The paging, the enumeration of the pages, or the pagination, excuse me, is like all messed up on this. But according to this online PDF, which is this multi-page petition on page 4 of 8, even though it's 50 pages, this is what she says. Ghislaine Maxwell proceeding pro se. And just as a gentle reminder, pro se means she is not filing this with the assistance of a lawyer. She is representing herself. Footnote, she has had incredibly competent, capable criminal defense lawyer, David Marcus, based here out of Miami, someone I know very well. She's had him through years of representation. So I find it to be very intriguing that there has been no co-signing of this particular motion in any way, or by David Marcus. So she's proceeding on her own. She's asking the federal court, pursuant to a federal statute, to, quote, vacate, set aside, or correct her conviction and sentence, end quote. So let's stop for a second here, right? So there's various relief that's being sought by Ghislaine Maxwell. She's actually saying, dear judge, based upon the following reasons, you need to either completely get rid of my sentence and conviction. You need to either set aside my sentence or conviction, or you need to fix it, that there's something wrong with it. So she could either get a new trial, she could either get a reduction in sentence. I mean, that's what she's seeking. I'm not telling you that's what she's getting. I'm just telling you what she's looking for, right? She claims that since the conclusion of her trial, substantial new evidence has emerged from related civil actions, government disclosures, investigative reports, and documents demonstrating constitutional violations that undermine the fairness of her proceedings. She's talking about the original prosecution and jury trial in New York that led to her eventual sentencing back in 2021. She claims that this newly available evidence derived from litigation against the FBI, various financial institutions, and the estate of Jeffrey Epstein, as well as from sworn depositions, released records, and other verified sources, shows that exculpatory information was withheld, false testimony presented, and material facts misrepresented to the jury and the court. The cumulative effect of these constitutional violations constitutes a complete miscarriage of justice, rendering Maxwell's conviction invalid, unsafe, and infirm. She raises what she says are 9 principal grounds for relief. She alleges that she has supported these grounds with newly discovered or previously suppressed evidence. She claims that no reasonable juror would have convicted her, and so she's seeking a vacating of her conviction, an evidentiary hearing, and other relief that justice would require. Fancy legalese for her basically saying, I want to get the hell out of prison, even though we know she's been the beneficiary of the Trump DOJ, putting her in a minimum security camp in Texas right now, where she gets to play with service dogs and she gets to go hang out and have her friends come and her families come, and she talks to her lawyers and she gets to go get exercise on her own, and she uses the warden as her bitch. Not my words, by the way, but from people that are there at that minimum security camp. She now is saying, I want the hell out. Alrighty. So just as a reminder, she's currently 63 years old and she's serving a 20-year sentence, 20 years in federal prison, convicted in 2021. And another reminder, she went to a jury trial and she was tried and convicted by a jury of her peers and sentenced by a federal judge. And just another reminder, she has attacked before the trial, during the trial, and after the trial, when she did have representation by incredibly competent counsel. She has attacked a lot of these same grounds. So this claim that there's newly discovered evidence is bunk. She interestingly cites in her habeas corpus petition to things like Netflix, because we know that there's been some, new kind of videos and documentaries and things that were generated as a result of the Epstein files kind of percolating back to the top of the media discourse recently. And, look, a lot of the claims that she raises, she's already tried. And so there's this way, if I can explain, please, there's a way of being able to attack what has happened to you. And it's kind of like direct appeals. And she's done it. And remember, she's gone all the way to the Supreme Court in the United States, who declined to take her appeal. And so now she's dead in the water, right? Like her ship is dead. It is anchored firmly to terra firma right now for that 20-year sentence. And even though she may be living it out in some minimum security kind of country club prison in Texas, it has nowhere to go. And so now she's trying desperately to do this. And again, I don't believe in coincidences, right? I mean, this is a very intentional thing, because what happens tomorrow? The release of the files, which of course she doesn't want to have come out, because it's just going to show even more of her culpability and guilt when it comes to this international sex trafficking rings of children. I will note that it could create a little bit of a wrinkle, again, as I mentioned a few minutes ago, in terms of the release of the files, because there could be a claim that in light of this habeas corpus petition, that it could impact her petition if the files are released. Look, I know that Bondi's going to look for every single straw to grasp to prevent the release of this information. Why? Because it harms Donald Trump. And that's why. Because if it didn't harm him, what shits would they give releasing it, right? But she knows it harms Trump. She knows it harms Trump's buddies and others. And that's part of the reason why she's also getting a directive, I am positive, to make sure that this thing is slow walked, slow rolled, or not sent out. Could I be wrong? Yes, I could be wrong. Just my opinion. Alrighty. So let's talk about this, because the grounds that are set forth in this petition run the gamut from the following. And let's go through it together. So it runs the gamut from the following: that a juror, specifically number 50, a guy by the name of Scotty David, gave false answers during jury selection because he concealed a history of sexual abuse that was directly relevant to the issues at her trial. She alleges that the civil lawyers representing victims and survivors of Epstein and Maxwell and others coordinated, quote unquote, with federal prosecutors. She cites to a Netflix documentary wherein the lawyers representing the victims said they were working in common interests, which, by the way, happens. And so there's nothing wrong with that. But she then says that these lawyers met with the government, and she alleges it's to, quote, foment the investigation. So she's suggesting that the only reason why the government investigated or prosecuted her was because the civil lawyers representing the Epstein victims and survivors wanted it to happen. Another argument she raises is that the United States breached the 2007 non-prosecution agreement reached between the government and Jeffrey Epstein. She says she was supposed to be the beneficiary of the immunity to any potential co-conspirators clause. Does that sound familiar? Yeah. Why? Because it's been litigated over and over and over and over again, and she's lost every single time she's tried to raise this as a bar to the prosecution. She's lost. So you can tell that she's grasping for straws and she's desperate because she brings it up again. But here's the thing. She makes an admission here in her habeas corpus petition that she, quote, plainly falls within the class of co-conspirator, meaning she's supposed to get that immunity from that non-prosecution agreement between Epstein and the Southern District of Florida. I want to stop for a second. We've talked about this before. So Ghislaine Maxwell is admitting that she is a co-conspirator of Jeffrey Epstein. Got it. Registered. Thank you. Thank you for that admission. I mean, to be the beneficiary of that co-conspirator clause, you have to be a co-conspirator. I mean, listen, her generous interpretation of that clause is that she's a potential co-conspirator. And yet we all know, again, this has been litigated. And even the Trump DOJ took the position that this non-prosecution agreement did not inure to her benefit, as in Ghislaine Maxwell, because it was not supposed to be for her benefit. Even Trump's DOJ said that. Maxwell goes on and alleges that the 25-year delay between alleged conduct committed by her and the indictment violated her due process because she was impaired in her abilities to present a defense. And that is revealed by trial testimony and new evidence. Again, she's saying the government could have indicted her several times in timely manners sooner, and they didn't do it. She alleges that the Assistant United States Attorney Marie Villafana, who was the lead driver in the Southern District of Florida, that she ordered the list of victims and their statements to be destroyed. She's alleging spoliation of evidence, not well-founded at all. She then blames Jeffrey Epstein, saying that his death denied her critical document access to defend herself, including full flight manifests. She also says that Epstein had access to the negotiation history of the non-prosecution agreement, and that because he's dead, she wasn't able to access his information. Nothing like blaming the dead guy, which, by the way, I still think is mysterious how that guy died. She then says that new evidence reveals that she was only indicted because Jeffrey Epstein was dead, and it was purely political motivation because they wanted to make sure that somebody was held to account for what happened, that it was only for expediency and purely political motives. She then blames the court for erroneous guideline calculations for her ultimate sentencing. And then she then throws in another argument that her pretrial confinement in the corrections facility that she was being held in New York was, quote, barbaric and contrary to treaties to which the United States is a signatory when it comes to not having cruel and unusual punishment, blah, blah, blah. It is her signature that appears at the end of the petition, just letting y'all know. She signs it, and she signs it clearly saying it was done by her, that she was doing it pro se. I mean, look, people, none of the exhibits to which she cites are included yet on the docket. And she just continues to make this argument that this is newly discovered evidence that would actually help her now try to vacate her conviction and her sentence. I mean, it's bunk. It ain't going to be well taken, and there's no obligation for the court to actually do anything, as in the court has no obligation to do an evidentiary hearing on it, et cetera, et cetera. I mean, this is yet another example of the following, though, which I think, we talk about jailhouse lawyers, and in this instance, it's because she got moved to this minimum security camp in Texas that she has time to be able to do this shit now. It's remarkable. We never saw it before. I mean, yeah, she had a lawyer, but we never saw her doing this before when she was being held in the maximum security location in Florida, right? But now that she's at this minimum security camp in Texas, suddenly she has all the time in the world to file a 50-page habeas corpus petition, etc. I mean, my only concern, again, I want to underscore this, is that the DOJ latches on to this to be able to say we can't release the Epstein files. And I will say this, her lawyer did argue in opposition to the release of the grand jury records in New York that was ultimately granted by a judge, that very thoughtful judge, Paul Engemeyer, who entered that multi-page order that you and I walked through here at the Katie Phang News channel. Like, You'll recall that the judge is methodically walking through the reasons why he's agreed that he's going to release these records. And remember, it's subject to a certification by the U.S. Attorney in the Southern District of New York, Jay Clayton, that he is guaranteeing that he's reviewed these records before they're disclosed to make sure that the victims and the survivors are protected in terms of their identities and personal information. But Maxwell's lawyer argues against the release of those grand jury materials, previously stating that the release would create, quote, undue prejudice so severe it would foreclose the possibility of a fair retrial should Ms. Maxwell's habeas petition succeed. Okay, so what does that mean? That means the following, that Maxwell's habeas petition is the one that she just filed pro se that we just walked through together. And her lawyers are saying that the information that's going to come even from the grand jury records, they're claiming is so severely prejudicial that it's going to harm her ability to be able to get a new trial or vacate her conviction and sentence, right? That just proves my point. That if the grand jury records being disclosed, which, by the way, are not a lot. Remember, all the federal judges said this is just a total kind of, smoke and mirrors move by the federal court to be able to say that there's, something big there when there's not. It's just like, sleight of hand by the DOJ, because really the DOJ holds all of the damning and substantial information, right? But if Maxwell's shitting her pants so badly about the grand jury records coming out from her Southern District of New York prosecution, can you imagine the treasure trove of information against Maxwell, Epstein, and others that's being held in the complete and total Epstein files that the DOJ has? Proven my points. So do not expect a huge tranche of information to be released tomorrow. Expect a battle to be able to get more, because you know what? Why in the world would Trump make it easy for us to be able to have information that is potentially incriminating and damning in terms of his involvement with convicted child sex trafficker, child sex predator, child sex abuser Ghislaine Maxwell, and her dead co-conspirator Jeffrey Epstein?
Thanks for watching. Be sure to add the MeidasTouch podcast on Apple Podcasts, Spotify, or wherever you get your podcasts for new updates every single day.